Article 34.2, subparagraph A, subparagraph 2 of the model law provides for the procedural grounds which denies a party due process. The party is not given notice or denied the opportunity to present his case. The right to due process is set out in Article 18 of the model law, and it provides for a framework of equality of treatment of the parties and the right of the parties to fully present their cases, which includes, among others, the right to information of all submissions in the arbitration proceedings and the proper notice of the initiation of the arbitration proceedings. This slide sets out examples where parties are deprived of due process and therefore would have sufficient grounds to set aside.
In the case of organizing a hearing, in practice, this is what happens. First of all, expect your arbitrator to be reasonable but firm. If your arbitrator is unreasonable, that may be cause for that arbitrator to have been doing something wrong or not proceeding with due natural justice. On the other hand, if your arbitrator actually is giving in to everything and anything that the parties want, then you also have some concerns that your arbitrator is actually not being firm enough. In organizing a hearing, your first step will be to hold a preliminary hearing. This is when, soon after an arbitrator is appointed, the tribunal will then call for a preliminary hearing whereby parties will attend, and the idea behind this preliminary hearing is actually to manage the case.
Let's take a look at the regime generally, right? Adjudication globally can operate as one, a dispute resolution regime allowing contracting parties to resolve all disputes under the contract, or it just confines to only the disputes that raised with the aim of determining the amount that is due and payable, and so ensuring payments are timely and reaches out to the claimants. Okay, so you have to appreciate that it can either be for just payment claims, or it could resolve disputes, and I'll show you examples of how that is. Essentially, with adjudication, there are two broad manners in which adjudication can take place.